Amy Pittman here with Pittman Law Office, and we're talking about healthcare decision making. So when we talk about healthcare in the estate planning world, we're talking about HIPAA, which is the access to medical information. So I can name my sisters, my brothers, I can name my kids, I can name anyone that I want to have the ability to talk to my medical providers. It's not naming a decision maker. It is just saying who can talk to my providers. And then I have a living will, which says, hey, if I'm in a vegetative state or end-stage condition, I don't want to be artificially kept alive. Now, living will is very standard. I could have a living will and never fit in that criteria. So it's not going to cover all end-of-life decisions. It is not a DNR. So a DNR is a do not resuscitate order. That's something you have to sign with your doctor. And then we have our healthcare surrogate. So we call it a designation of a healthcare surrogate. Other states may call it a healthcare power of attorney or a healthcare proxy. That healthcare surrogate is the person who's going to make your medical decisions if you are unable to. So you really want to think about who you're putting in this position. Don't just name your oldest kid because you don't want to hurt her feelings. Name someone who's going to understand your wishes, follow what you would have wanted, and also that's able to end your life, that they're able to make an end-of-life decision. If they can't kill you, don't name them. I know that sounds harsh, but I would not want to put that responsibility on someone who's going to really struggle with that and may need to see therapists afterwards. So really think through who this person is, and definitely name successors. So if I name my husband first and then my sister second, and then another person, that allows that person, if maybe they can't handle that decision making, to decline to serve, and it goes down to the next person. And really have conversations with that healthcare surrogate that you've named so they understand quality of life. Don't just think that, oh, they're going to reach out and look at my document and understand. So our documents are just giving them the power. It does not go into detail about quality of care or quality of life. So we really want you to have conversations with that person you name so they understand what you would want. Definitely if there's a diagnosis, you want to kind of walk them through what that looks like for you. You know, if you have a family member or a friend or neighbors, especially for clients who live in retirement communities, we're surrounded with people having medical events. And those are really good examples to use when you're talking to your healthcare surrogate. So again, think through your healthcare, especially clients of ours. Look through those documents that you did with us. Make sure those people are still the right people to make your healthcare decisions. I hope that helps. And that's estate planning the pink way. Have a good one.